Yeah, this started when the 2011 Preferential Procurement Regulations were really questions in terms of how effective they are. And a task team was put together by National Treasury, Department of Trade, Industry, Enterprise Development, Economic Development, and Public Enterprises. And that resulted in then a update to the regulations, which we now call the Preferential Procurement Regulations 2017. And already when they were issued in draft, Afribusiness started to complain and contest, and eventually tried to get the Gauteng High Court, to set aside the 2017 regulations. They were unsuccessful in that one. They tried to appeal. The appeal was dismissed, so they took it to the Supreme Court of Appeal, which heard that the arguments 8th of September. And then the 2nd of November 2020, the Supreme Court of Appeal declared the entire 2017 regulations invalid. But they suspended that order of invalidity for 12 months. They appealed it to the Constitutional Court. The hearing happened on the 25th of May. And yesterday at 10 a.m., the decision was handed down, and the Minister of Finance, the appeal by the Minister of Finance was dismissed with costs. That's where we stand at the moment. If we then take that, I think there's a bunch of questions that people are asking. These are what we're getting from a number of people. What does this mean? Does it mean we revert to the 2011 regulations? Do we now wait for National Treasury to revise the regulations? How does this affect the tenders that were issued or closed since the 2nd of November 2021? What about the tenders that are still active, not yet closed? What about the tenders that were going out today, tenders and quotations? Can we still pre-qualify? And is it if feasible, must we still subcontract if it's more than 30 million rand? What happens to the local production and content circulars? Why the frequent reference in the Act to Section 2.1 of the PPPFA? And are there any changes that we need to make to our policies? A couple of questions, and just to try and give us some structure, what I discussed with Prof Geo is, let's try and just follow these five. Just the highlights of the case. Where do we stand now in the legal process? People are already saying, well, this is going to be appealed. Can it be? What does this mean for the tenders and quotations that are out? Why the reference to 2.1 of the Act, and what are the SCM policy implications? And then we can discuss briefly the unintended consequences of this. Prof, please chip in if I misinterpret anything going through now, just picking out a couple of points in the case. So this is the Minister of Finance and Afribusiness, Fidelity Service Group, and South African National Security Employers Association were two intervening parties. You'll see throughout the judgment there's reference to them, but I'm not going to spend time on the conclusions about their request to intervene. In the minority part of the judgment, they basically outline the key questions that are being asked of the Constitutional Court: whether the minister acted beyond the scope of his powers when he promulgated the impugned regulations. This question requires the court to consider the following issues: whether the 2017 regulations are inconsistent with the Procurement Act. They're referring there to the PPPFA. What is the scope of the minister's regulatory powers in terms of the Act? And lastly, whether the 2017 regulations are inconsistent with Section 2171 of the Constitution, such that they are invalid. There were two. It was not unanimous. The minority judgment was 4 of the justices, penned by Justice Matlantla, in fact read by Justice Matlantla, and the majority judgment was read by Justice Madlanga. They agreed with all of the minority judgment decisions except the one on the minister having the power to make the regulation. Is that right, Prof?
Yes, more or less, yes. So they agreed on all the procedural matters, which I don't think need to detain us. Yeah. But it's on the substance of the appeal where they actually disagreed and then took a much narrower view and decided basically on the merits of the appeal on one single basis.
Great, thanks. Let me quickly share the results of those that are online. About 23% of you have read it in entirety, 36% have not read it, and 41% of you have actually scanned. So there we've got a good number of you that have actually at least scanned it and looked at it. So in the minority judgment, there is a number of points that are made. The Constitution itself empowers the state to adopt procurement policies that prefer certain contracts be allocated to persons that were previously disadvantaged by unfair discrimination. You'll see throughout, I'm not going to go through these in much detail, but throughout the minority and majority judgment, there's a lot of references to 2172 and 3 and the interplay between 2172 and 2171, and really talking a lot about the references in the Constitution to policy and to framework. And if you're not familiar with those, then important to have a look at that. The conclusion from the minority was that they would have set aside the Supreme Court of Appeals decision and really dismissed it with costs. That was not what the majority went with. Here are some summary points that I think would be of relevance to people in the public procurement space. In my view, the impugned regulations are not necessary. We'll come back to necessary. The impugned regulations are meant to serve as a preferential procurement policy. Throughout the first judgment, Section 2.1 of the Procurement Act provides that an organ of state must determine its preferential procurement policy and implement it within the framework. Throughout the majority's judgment, there's this reference to 2.1 of the Procurement Act, 2.1 of the Preferential Procurement Policy Framework Act. The Act is plain in that national legislation envisioned in Section 2173 of the Constitution and is provided for in that section. The object of the Act is to achieve what is contained in Section 2172 of the Constitution. So what is necessary for the purpose of the Procurement Act and by extension for purposes of 2172 of the Constitution is provided for in Section 2.1 of the Procurement Act. Preferential procurement policy must be determined by each individual organ of state, and it must be implemented with the framework that is set out in Section 2. And then, Prof, the whole thing then moves towards the whole issue of necessary and expedient, and the difference between the interpretation of the minority judgment and the majority judgment on that issue of necessary and expedient. And 116, it can neither be necessary nor expedient for the minister to make regulations that seek to achieve that which can already be achieved in terms of Section 2.1 of the Procurement Act. Happily, both the first judgment and this judgment, and indeed the minister, understand the impugned regulations to do what is envisaged in Section 2172 of the Constitution. The Procurement Act, in particular 2.1, gives effect to Section 2173, which provides that the preference envisaged in Section 2172 must be provided for in national legislation. The minister cannot, just because she or he feels that her or his idea of preferential procurement policy is not being introduced by organs of state, arrogate to her or himself a power that she or he does not have under the Procurement Act. Minister's perceived need for a particular type of preferential procurement policy is simply not enough. And then the concluding statement, the Procurement Act has stipulated the means of or adopted a plan for determining preferential procurement policy. The minister is now adding different means or varying the adopted plan. He cannot do that. There's just two concluding sections. Interesting question that arises around the first judgment's approach, assuming that a preferential procurement system created by the minister by regulation conflicts directly with one created by an organ of state. Which one will take precedence and why? And then, interestingly, it goes on to say that although there might have been some reason to have the regulation, the question is that, does the minister have the power to issue the regulations? And concluded no. And I think that's the summary there, Prof Geo. The upshot is that the following order is made. I'll just jump through 1 and 2. The leave to appeal is granted, so they can appeal to the Constitutional Court, and the appeal is dismissed with costs, including the cost of 2 counsel. That's where we stand. 3rd of November, National Treasury issued an advisory to everybody and said the following: the appeal to the Constitutional Court suspended the SCA judgment. Should the Constitutional Court dismiss the appeal by the Minister of Finance and uphold the decision of the SCA, the Constitutional Court will, in its judgment, indicate the period of suspension of invalidity to allow the Minister time to amend the regulations. Therefore, while awaiting the judgment, institutions must continue to comply with the Preferential Procurement Regulation 2017 in their procurement processes until further notice.